Good morning, Europe. Good afternoon, Southeast Asia and China, and I don't know about Latin America. My name is Marta Bettinazzi, and I am the IP Business Advisor at the Southeast Asia IPR SME Helpdesk. And today I will be the moderator of this webinar. Before we start, I want you to have a look on the panel of your right, where you can find a question box and a chat box. Please feel free to use them to ask all the questions you want to ask during the presentation. Be also informed that our presentation are going to be recorded and published on our YouTube channel alongside with the PPT. So if you miss something, you can always catch up there. If you want to ask more questions after the webinar, we were also happy to answer later on. Today, we will have our speaker, Mr. Elio De Tullio, discussing how to internationally protect your trademark through the Madrid system, and then we expect to have a very alive Q&A question with questions from the audience. Please also be informed that during the webinar, we will ask you questions because it's our turn to ask questions through the poll system. You just have to answer, and there is no, we don't judge you. It's just to measure how it's going. It's to keep you alive, actually. So who are we? We are an initiative of the European Commission that under DG GROW around 3 help desks, China, Latin America, and Southeast Asia. We all ensure inquiry helpline where you can address your questions regarding the 3 geographical areas and IP, but you can also attend our webinars. We sometimes do it like today all together, but some other times we do it individually per region or even per country. If you visit our website, you will find a lot of materials from guides regarding countries, fact sheets, but also e-learning modules and other interactive tools that can help you having a better understanding on how to deal with your intellectual property. So for today's speaker, we have Mr. Elio De Tullio. He's an Italian lawyer admitted to the bar in Italy, and he's a trademark attorney with 10 years of experience. And he's the founder of his own law firms that he has office in Rome and Bari, and also in New York. And he acts as a trademark attorney and is especially knowledgeable when it comes to assess the IP protection and discuss an IP strategy. He don't just litigates in front of the Italian court, but he's also specialized in different international countries, including in particular Chinese and Southeast Asia markets. And with this very short introduction, I will leave the floor to our speaker, and I will be back for the Q&A and for the poll question. Thank you, and enjoy your webinar.
Thank you, Marta. I will take the lead of the presentation. So now you should see the presentation. Please confirm.
Yes, we are seeing it.
Okay, great. So today the topic of today is one of my favorite topics because the international trademark system, the Madrid Agreement, is really revolutionary instruments in the intellectual property. Think that the original instrument was discussed and approved at WIPO, the World Intellectual Property Organization, in 1891. So we are talking about more than 1 century ago. And then after some revisions, the protocol was approved in 1989. So from that time, constantly number of new members adhered to the international registration system of the Madrid Agreement. Now it's called the Madrid System because it includes the Madrid Agreement and the Madrid Protocol. And now we have 122 countries members of the agreement. Why is it so important? It's so important because it is the only instrument that allows applicants, companies to obtain protection in more than one country with one single application. Now we'll see how this works. Of course, we will also have a look at some successful cases and takeaway messages. So first, before starting, Marta will launch this first poll question. So Marta,
yes.
the floor is yours.
Yes. How many of you are using the Madrid system to protect your own trademark? The majority of you, few of you, other protection systems are preferred, no registration at all. So basically, if you have registered, you vote for A. If you are unsure, you vote for B, and C is for those that decide not to use the Madrid system. And we will keep the question running for 1 minute, more or less. So please vote, make up your mind and vote. Okay, you have another 10 to 20 seconds to vote. If you are still uncertain, please make up your mind, and we will share the results now. So we can see that the majority is actually the vote for A, so they have registered or they are considering to register. So that's our poll, and actually not many are those that don't want to register, which makes sense considering they are attending a webinar on the topic. So I think, Elio, do you want to comment?
Well, it is interesting that applicants or companies would like to know more about the system they are already using. So it's even better for us. Yeah.
So, okay, we can go back to the presentation. Okay.
So first of all, some statistics. These are the key numbers for 2019 published by WIPO. These are publicly available statistics, so you can have a look at WIPO website, and there is a publication of 150 pages, so you can get lost in these numbers that are very interesting, because you can see that there are always increasing numbers compared to 2018, and we are talking about more than 66,000 applications, and very interesting numbers in terms of designation. As mentioned before, now the countries covered by the Madrid system are 122. In terms of classes, you know that an application for registration can be registered for one or more specific classes belonging to the International Convention of Goods and Services. In terms of classes, the most preferred classes are those related to technology. So class 9 for devices, for electronic devices, class 35 for the management and the all the operations related to administrative management, franchising, merchandising services, and class 42 that is technology transfer and innovation services. So who filed the most Madrid trademark application in 2019? These are the top 10 Madrid applicants. You can see that there are companies coming from luxury goods, but also companies belonging to pharmaceutical sector, technological sector, and also mobile device sector. There are also companies coming from automotive that are still very good applicants using Madrid System. As we'll see afterwards, the Madrid System has to be used together with the local national system of protection of trademarks, because the countries members of the Madrid System are not all the countries of the world. Of course, they are increasing, their numbers always increasing, but we are still far from covering all the countries of the world. The top 10 countries in terms of number of Madrid application and percent growth since 2018 are US, that are the best Madrid applicants, Germany, China, but as you can see, there is a huge presence of all countries, European countries, and also non-EU countries like Japan, Australia, Switzerland, and Turkey. The second poll question, so Marta, the floor is yours.
Yes, so do you consider the Madrid System the best solution for companies that operate globally? Yes, is the best solution, as it's is a cost-effective system. B, it depends on the mark and the countries of interest. C, no, the Madrid System procedure involve high risk. We launch now the poll. You have, again, 1 minute and something to answer, and then we will comment the results. You, let's say, still have another 10 seconds to make up your mind, but I see a clear majority here. So let's close the poll. And okay, no one thinks that is too high risk. The majority thinks that depending on the country is actually a good idea, and only 33% thinks that, yeah, absolutely, the Madrid System is the way to live in any case. Elio, do you have any comment before we go back to the
comment? Is that the answers are reasonable, because we always have to be very careful in using systems like the Madrid System. I mean, the ambition of SMEs is always to grow up. So at the very beginning, so before launching a product on the market, we are, let's say, glad that they think that exporting products and services all around the world is the goal. But we should always find a balance between ambitions and so expectations in terms of market and real situation. So the Madrid System is always good, because you can have one application claiming 122 countries. But then the trademark, let's say, management needs some other activities like prosecution, like enforcement, like monitoring, like taking care of your rights. So a good balance should be found, and that is why it depends on the mark, and the countries of interest is the right answer, because of course SMEs should focus on the effective market, those markets that are very important for them.
And also, as I always say, if you ask a lawyer, the answer is always it depends.
Yeah, well, that's true. That's true.
So, yeah. Okay, we can go back with the presentation.
Yeah, it's not like a formula, but the problem is that a case-by-case analysis should be carried out, and
it's actually the best idea. It's true.
Yeah, and I would say devil is in the details, and you should always consider all possible worst case scenarios in order to assess good consultancy, good piece of advice to SMEs. So let's go back to our presentation. So what is a trademark? This is only a background information. You all know what is a trademark. In general, it is possible to register as a trademark word marks, figurative marks containing word elements. Shape marks consist of three-dimensional shape marks containing word elements, position marks that protect the specific way in which the mark is placed or on affixed to the product, pattern marks that are signed where a set of elements are regularly repeated. Of course, there is also a world of non-traditional trademark, non-conventional trademarks. For instance, most of them have been now, let's say, approved by the new guidelines of EU IPO. Let's say the possibility to register non-conventional trademark is always under dispute, because you never know what is the substantial examination carried out by the office. Generally speaking, the special category includes marks that differ from the usual concept, so colors, motions, sounds, scents, holograms, but not all countries and not all offices consider them the same way. Although non-traditional marks exist across the world, so not all of them can be registered, and the protection is particularly difficult due to the lack of widespread uniform standards. What are the benefits protecting the trademark? Trademarks are valuable assets, so they are considered in all extraordinary operations and transactions involving companies, for instance, joint ventures, licensing, or investments, or in case companies can be purchased by another company. So all the due diligence involving companies or involving some very important contracts for companies like technology transfer or licensing, they involve also a due diligence on trademarks and on IP rights. They protect brand value because they are able to build your business value and reputation. They make you recognizable at international level, even in countries that are very far from your country of origin. There are ways so consumers can find you and can understand that those products and services, those high quality products and services come from you, and they are able to create the basis in order to enforce your right, to prevent counterfeiting and fraud, to avoid imitation, to start litigation before the courts for IP infringement. What to do before starting any trademark registration? Of course, carrying out preliminary searches, so searches in order to identify if identical or similar marks are already registered in the market of interest. And now we'll see some publicly available database, so you can check personally some information about trademarks that are similar or identical to yours. But my advice is always to go to a lawyer or to IP attorney in the country of origin. So if you are based in EU, you need an EU lawyer. If you are based in an EU country, it's better to select an EU IP attorney, so you can have not only the extraction of data, but also the interpretation of data according to the prevalent legislation and practice. So those data shall be interpreted according to the jurisprudence and the practice of the Office of Destination. So priority availability searches help you to avoid refusals issued by the IP offices of the countries in which protection is sought. They reduce risk of conflicts with third-party owners of prior rights, so they reduce the possibility to receive administrative opposition proceedings or legal action, and of course they allow you to save this money, because at the end, knowing before starting, before going to the market, is better than find yourself in the middle of the lake where you don't know how to go ahead and you would not like to go back. The searches can be carried out on territorial basis. Of course, you can also carry out a worldwide search. The better is to carry out very extended searches in terms of territories, in terms of classes, because you can also include the classes that are not part of your core business at the time of the execution of the search, but they can be part of your future business in 1, 2, 3, up to 10 years, so the duration of the trademark registration, so you can foresee, you can prevent possible limitation or possible use of your trademark in some products and services that are similar to the one of your core business. So at the end of the day, these searches, together with the legal opinion assessing the data, are able to allow you to know about the free use, the valid registration of your trademarks in the countries, even the countries belonging to the Madrid system. So how to check your trademark availability? You can use, as mentioned before, a free available database like the WIPO Global Database, where you can get information about all the countries belonging to the Madrid system, but it's not really easy to use Boolean characters and to extract, to get genuine and usable data. So sometimes these data can be misleading. Of course, you can use also the EU APO database that are excellent, like TMView, ASEAN TMView. If you are like to check you can search. You like to search in the ASEAN countries, but once again, this can be a first, let's say, a first assessment. So if you find an identical trademark in the real class of your interest, probably you can think about an alternative. But apart from this case, the extraction of data should be accompanied by a legal opinion. So an opinion about the free use and the valid registration in the country of destination. Sorry. What is the Madrid system? The Madrid system for the international registration of trademarks is a cost-effective solution for registering trademarks worldwide in the territories of the contracting parties to the Madrid Agreement and Protocol. Once again, now we have 122 countries, and the system is administered by the International Bureau, the WIPO, and allows trademark owners to protect their marks in several countries by filing one application and obtaining an international registration that takes effect in each of the designated contracting parties. Moreover, it's also possible to extend the protection to other countries filing the subsequent designation. How does the Madrid system work? The most important thing is that the basic pillar is the basic registration. So the registration in or application in the country of origin. If you have a registration in a country of origin that belongs to the Madrid system, you can also file an international application based on the national application of origin and claiming one of the 122 countries members of the Madrid system. So at that stage, the office of origin, the application will be forwarded by WIPO, by the World Territorial Organization, to the office of origin. After WIPO carries out a formal examination of the international application. At this stage, you will receive a registration certificate, but you cannot be misled by this registration certificate, because you need to wait for 12 or 18 months until the office of destination can issue a provisional refusal or can carry out a substantial examination of your trademark. Indeed, IP offices of designated contracting parties carry out substantial examination, and the final decision on the registration in the territory of the designated contracting party is issued. So, what are the main steps of the process? So the application, first of all, first step is file the application through a national or regional office, so the office of origin. Once again, don't forget that you need to have a basic registration or basic application in the country of origin. Then this application is forwarded by the country of origin to the WIPO that carries out a formal examination, so an examination on formalities, and then a substantive examination is carried out by the IP office of the designated contracting party that issues the final decision. So let's go a little bit more further in these steps. So the applicant needs to have already registered the mark or have filed an application with the IP office of origin. So the basic mark, the international application must be submitted through the IP office of origin, which will certify it and forward to WIPO. Then the applicant should classify the list of goods and services in accordance with the International Classification of Goods and Services by the Madrid Agreement. This is a very important step, because somehow each country can apply international classification in a different way. There are different practices, so products and services can be classified by the offices of destination, the trademark offices of destination, in different way. Moreover, the examiners in the countries of destination can apply your discretionality in assessing, for instance, the main requirements of validity of the trademarks, for instance, distinctive character or novelty. Think that some examiners, some offices in some countries carry out an examination only on absolute grounds, so the lack of distinctive character or the descriptiveness. But some other countries also carry out also examination on relative grounds. So they also see if a trademark, similar or identical trademark are already present in the registers, and in these cases they can issue a provisional refusal. So on one side, classification of goods and services. On the other side, let's say the presence in the registers of similar identical trademarks can be, let's say, potential obstacles in terms of registration. That is why preliminary searches are very important. Application costs. This is a very important issue because this is the main reason why the international registration through the Madrid system is successful, because there is a huge saving of costs compared to the case in which you should file different application at national level. So let's say we have very good advantages. So probably you save 10 times the money you should use to obtain protection, so registration in all the countries in which you would like to register your trademark. Generally speaking, the cost of international registrations include a basic fee, a complementary fee or individual fee for each designated contracting party, and a supplementary fee for all classes beyond the third class, so for these additional classes of goods and services. Some contracting parties require also the payment of a second part fee after the registration of the trademark in the country of destination, so like Japan, Brazil, and Cuba. So it is always very important to foresee and to estimate in advance also the second part fee, because, for instance, in Japan is quite expensive, in order not to find yourself surprised in case you receive the request from the office of destination. So another thing, a very important thing, is that you should assess very well in advance the classes of your application, because in the future you can reduce the products and services, but you cannot extend the protection to other products and services. So the preliminary assessment is very important. Once the international application has been submitted, WIPO conducts a formal examination to verify that it complies with the requirements of the Madrid Agreement and Protocol and their common regulations. In the absence of formal irregularities, WIPO registers the mark, so it issues a registration certificate in the international register and publishes the international registration in the WIPO Gazette of International Marks. So at this stage, a certificate of the international registration is issued and the notification is filed to the IP offices of the designated contracting parties. But this registration certificate sometimes is misleading. So companies applicants think that they have the trademark registered already in all the country of destination, so all countries claim it in the original application. That is not the right information, because you need, as you can see afterwards, you need that the offices of destination will not issue a formal, partial, or total refusal, so an office action regarding the basic validity requirements of your trademark in the country of destination, according to the claimant office, the trademark office jurisprudence and practice. So indeed, the IP offices of the designated contracting parties proceed with the substantial examination of the international registration, so distinctive capacity, novelty. Sometimes the Chinese office, the CNIPA, carries out also a novelty search. Let's say you should be very careful, because if your trademark, for instance, contains geographical names or contain quality or types of elements related to goods, to the goods and services claimed, or if it is generic, or if it is not new, of course, so you can receive an office action. So if no objections are issued, the IP offices of the designated contracting parties can issue a decision within the applicable time limit, the issue of registration. Otherwise, you will receive this objection. Indeed, the designated IP office can provisionally refuse totally or partially the protection of the mark due to non-conformity with national laws or on account of existing prior rights of third parties. So there are a lot of potential problems. For instance, the classification is not correct. There are some problems related to the translation of the trademark in the language of the country of destination. There are some problems related to the presence in the registers of prior rights or a lack of distinctive character according to the local consumers. So that is why preliminary searches are very important, and the legal opinion is very important, because you can assess in advance all these potential problems. So it's a kind of risk management activity any SME should carry out before filing international, because it's a matter to save money, to reduce time and energies to achieve registration. The applicant can reply to the provisional refusal, and this procedure is completely carried out by the competent IP office of the contracting party concerned. So in any case, the International Bureau is informed about the final decision. If there is no refusal within the applicable time limit, the protection of the trademark in each designated contracting party is granted, and the international trademark has the same protection as a national trademark in each country. So the protection lasts 10 years from the filing date, can be renewed through WIPO directly. It is possible to add countries through a subsequent designation connected to the registration already granted. That is very important, because this modular characteristic of the international registration is very interesting. You can extend protection. Be careful that you cannot extend protections in terms of goods and services. So that's why the you are kindly invited to extend as possible the protection, the original protection, because then you can include all potential products and services belonging to your potential business. But otherwise, you will be requested to file a new application in case the products and services of interest are not included in the original application. Moreover, you have to bear in mind that for a period of 5 years from the date of the registration, the international registration remains dependent on the basic mark. Don't forget to renew the basic mark, because the basic mark is independent from the international registration. So what are the advantages of the Madrid system? First of all, it's a centralized filing system. So a single application in one language, English, French, or Spanish, through the payment of one set of fees in Swiss francs, rather than filing different applications in each country where protection is sought. Don't forget that if you have more than one trademark, if you have more than one class, probably you should also find a very, very good administrative advantages in terms of management of these application registration. It's also a cost-effective system, because the trademark owner can avoid all the translation costs, some exchange-related expenses involving the different national and regional procedures that are conducted in various languages and require fees paid at national level. You also have one deadline for all designated countries. In addition, a single renewal application will be effective in all the designated countries. So starting from the registration is consolidated, you can avoid intermediaries cost. You can renew directly through WIPO. Once the international application, the international trademark has been granted, it is possible to record the change of name or address through one application. So you need to find, you do not need to file different recordals of change of names or address in all the countries of destination, but one is enough. And then final advantage is that since the formal examination has been already carried out by WIPO, national IP offices do not need to carry out a formal examination or publish the mark, because the publication is done by WIPO. So at the end of the day, you reduce the risk to receive several, for instance, objection regarding formalities at the very beginning. What are the disadvantages? The first disadvantage is that it's related to the fact that you file on your own without the assistance of a lawyer or IP attorney, because of course in this case you reduce a lot the risk to receive office actions, because such classification system should be checked and should be assessed before filing in connection with the classification practices applied by the different national IP offices. Some IP offices, they use their own practices, their own jurisprudence, and examiners have also very good level of discretionality in considering the receiving application. So either in terms of classification, also in terms of absolute and relative grounds, they can carry out substantial examination, and some problems in terms of receiving office action can be raised. Moreover, in some cases, you need to reply to this office action in very short time limits. For instance, 15 days. So in 15 days, you should, if you do not have an IP attorney, you should carry out the preliminary assessment on the case, designate a local IP attorney, because you cannot be represented in the country of destination on your own. Then, of course, reply. So write a reply to the office section. So it's not an easy task. Another thing is that so the identification of goods is not easy and should be very carefully assessed. Indeed, some countries have local issues, so you need always to check these local issues before filing. And another issue is that within 5 years of the international registration, the basic mark is amended or revoked in the country of origin to the prior third party rights, or following a declaration of invalidity or an office action, the international registration will also be consequently amended or cancelled. So that is called the so-called central attack. So the problems related to the basic application registration can have an influence and can involve related problems in all the international application. Another issue is that if you have to start an enforcement activity, or you have to start litigation before the court, some courts require the issuance of a local registration certificate. So the international registration certificate is not enough in order to enforce your rights locally. So in this case, the request of the specific request of the national portion of the international certificate issued by the local office could be an option, but don't forget that you will need time in order to obtain it. This is a successful case study. It's related to an Italian food company that has used the Madrid system, claiming in different countries So it has consulted its own IP attorney. It has carried out the preliminary classification assessment. Then it has registered the trademark at international level. So in this case, it has been successful in enforcing its rights against illicit and unauthorized use of IP rights. This is a typical case of a company with interest in more than one international country that is able to save money in order to file and register the rights, the trademark in destination countries, and also use these rights in order to enforce them before the court. So at the end of the day, the takeaway messages are: start protecting your mark before entering the market, develop a strategy for your trademark protection, even in this case before starting any filing, carry out preliminary searches at worldwide level. That is a suggestion. Of course, if you would like to reduce costs, you can also consider regions or specific countries. Take care of your first filing. As mentioned before, the first filing is the pillar of the international protection. So the first filing can be the basic application registration of the international registration, but don't forget that you also have the priority rights accorded by the Paris Convention. So you can file an international registration or an application in any country of the world within 6 months from the first filing, using the priority rights accorded by the Paris Convention. Monitor markets and competitors' behaviors. That is very important in order to react promptly. Activate through your IP attorney a worldwide surveillance system in order to monitor future filings of similar and identical trademarks for the same products and services. Monitor IP gazettes and legal actions, and manage your entire portfolio of international trademarks in order to reduce costs, save energies, and being effective in your registration strategy. Finally, two updates about the COVID-19 problems. As you can see, there is a special page on the World Intellectual Property Organization website where you can double check all is related to the emergency and the practice of the IP local offices in order to afford these circumstances. The issue is that WIPO is controlling, is monitoring all the operation of national offices, and you can also check on your own through this IP policy tracker all the information on measures adopted by IP offices in response to the COVID-19 pandemic, such as extension of deadlines, and then there are also information on legislative and regulatory measures for access and voluntary actions. So you can just check, open these pages in your browser and understand if some measures in this transitional period has been applied and how long. So I'm happy to answer your questions, if any. Thank you.
Thank you, Helio. Thank you to everyone that has been here. We have some questions. First of all, we received 2 questions before the starting of the webinar, and one was asking how we can calculate the taxes, so I will assume the fee for the application and renewal, but I would say this was covered by your presentation. Helio, if there is anything more you want to add, feel free, but I will consider it answered by the presentation.
Well, indeed, there is one thing I forgot to mention in my presentation. So you can calculate on your own through the fee calculation fee calculator the international taxes to be paid at WIPO, even at the time of the first application, but also for instance, the subsequent designation, you should consider that some, for the first filing, some taxes, so some official fees have to be paid at the national office that will transmit the application to the WIPO office. For instance, in Italy is around 250 euros. But generally speaking, you should consider that you can calculate on your own international taxes.
Yeah, it's actually even quite funny because you can start playing with the countries and deciding where you want to go. Anyway, yeah. We have another question, which actually is a block of questions, because we have a first question asking from the same person. Will this type of trademark protection system be in place to companies' registration of trademark when the UK leaves the Union? And then the same person was asking also, when you register your trademark in the patent office of the UK to cover China, are you automatically then covered for the Madrid system? I think this needs a little bit of translation. And how can you do a fast check to see if a trademark is not being used by a company in China? So this last one regarding the check, can we say maybe that you can have a look of the international trademark searching? And for the other two, I don't know what you would like to say, Elio.
Okay, I would like to start from a tail of last answer.
Yeah.
Saying that when you play with this fee calculator WIPO, don't forget to save, let's say, an amount of money for prosecution, because of course you can register, you can file an application for registration for paying not so many money in terms of application fees, but then you can receive office actions, and so you have to prosecute your application. So it's better to save money in order to face with this prosecution phase, so you can have a very reduced risk strategy. Then back to the other questions. As to Brexit, the situation is not easy. So I would suggest the organizer of Southeast Asia, China, and Latin America to organize a specific Brexit webinar, because it's very complicated stuff. Even if we are still in a transitional period, so we don't know how the situation will evolve. Generally speaking, you know that the Withdrawal Agreement governing the divorce phase between Brexit and EU is official starting from January 31st, 2020. So it was open in the transition period starting on February 1st, that will last until December 31. So right now, let's say there are possible scenarios, but generally speaking, I would suggest, in order to reduce risks, to, in any case, to claim UK in your international registration if you have already an international registration. This is very basic. Then there are some possible scenarios. For instance, generally speaking, these scenarios can regulate the future relationship between UK and EU, even in connection with international registration. So, for instance, it was mentioned that for each designation of the EU in which the mark is protected before the exit day, the office of the UK, so UK IPO, will automatically create a new registration at no cost. This also under doubt, because it depends on the level of the Brexit, if it's an hard Brexit or a soft Brexit. This new UK registration will be governed by UK law and will be independent from the international registration. So the newly created UK registration can be replaced by the corresponding international registration, provided the holder subsequently designates the UK after the exit date. So in such case, it is advisable that the holder requests that WIPO take note of replacement in the UK register in accordance with the Article 4 bis. The problem is more complicated for each designation of the EU pending before the exit date. So in this case, the holder should have 9 months from the exit date in order to file an application for the registration of the mark in the UK. In this case, the application would benefit from the date of the pending designation of the EU and, where applicable, from any priority claim. But there are several scenarios about this. So let's say that if you have a registration, probably you will not have problems. If you have an application, probably you can have problems. But in order to reduce at the maximum level the risks to not to have protection in UK, probably you should consider to extend the protection of your international registration claiming EU to UK, or to file a UK independent application, so you can also be sure that your trademark will not be unprotected in UK. And
yes, yeah, please.
You have another question, right?
Yeah, we have 2 other questions actually from another attendee. She's asking a change of name, address, etc. should be filed through the office of origin in case the international registration is dependent on the basic mark, or through WIPO. So if I have to change my name and address, do I have to communicate it to just my national office, or do I have to go to WIPO?
It can be done directly to WIPO if the registration, the international registration is already consolidated. You can go directly to WIPO. That is one of the advantages of the international registration. So you cannot, you should not have to go in each destination offices.
But it's also not enough to go to your national office, so you have to go to WIPO.
You don't have to go to your national office.
Okay, and then for some reason, for example, refusal, an international application might become empty. Is still a valid trademark or become invalid?
Well, you always have the basic application registration on which your international registration is based. If you have a basic registration, and if you have an international application that has renewed, is still valid. Of course, there is no need to keep an international registration in which you need to pay renewal fees if the protection is not sought for any country. So it would be very strange.
Okay. So with this,
you still have this dependence on the basic application registration.
Okay.
Yeah.
So with this, we are done with the questions. So I encourage all the participants to send more questions via email. You will receive all the information regarding also the international help desk in our follow-up email. Now you see on the screen the brand new guide that has been developed thanks to Elio, that will soon be published on our website. And I want to thank you again, all the attendees and the colleagues from the other help desks, and of course I want to thank again Elio for being here and to be so supportive with our project. You see on the screen all our addresses and links to find us. Thank you.
Thank you to all.